further facts regarding the unavailability of information, the hurried and confused notice that the individual received, language barriers, and the attorney's access compound and confirm this court's finding that no reasonable interpretation of the court's preliminary injunction could endorse yesterday's events. So, the way that this is spun in the media is that there's a quote from a judge. What was it? That he undoubtedly violated a court order. Plaintiffs and the proposed class members are non-citizens with final removal orders resulting from proceedings in which they have been notified that they could be deported to a designated country of removal, and in some cases, an alternative country of removal. And they had the opportunity to contest their removal to a designated country based on their claim of fear. They bring this class action to challenge the policy or practice of the Department of Homeland Security of seeking to deport them to a third country and never... Wait, hold on. Who's this filed by? They bring this class action to challenge the policy of the Homeland Security of seeking to deport them to a third country, a country never designated for removal, without first providing them with notice or opportunity to contest their removal on the basis that they fear persecution, torture, or even death to that third country. Okay. So, non-citizens with removal orders to their country of origin or other countries or other specific countries lawsuit alleges that the government attempted to deport these people to other countries with no ability to contest removal to said country for fear of prosecution. Okay. DHS policy or practice of failing to afford these basic minimal protections violates the Immigration and Nationality Act, the Foreign Affairs Reform and Reconstructing Act, the Due Process Clause of the Fifth Amendment, the treaty obligations of the United States. Indeed, the Officer of the Solicitor General recognized these legal obligations when it informed Supreme Court in Johnson v. Chavez in 2021 that DHS will not deport to a third country non-citizens with final orders who have already been granted protection by an immigration judge until after these individuals receive meaningful notice of the opportunity to assert fear-based claims against removal in that country. As plaintiffs proposed, class members cases demonstrate as litigation after the OSG representatives revealed DHS has no written policy to provide non-citizens either with the opportunity or the opportunity to present a fear-based claim before DHS supports them to a third country where they face persecution. The absence of written policies and procedures has in the past resulted in cases where individuals, including those granted protection from removal, were deported to third countries without warning. But on February 18th, 2025, DHS issued a policy directive that magnified the practical impact of this lack of written policy. The directive instructs DHS members to review all cases of individuals previously released from immigration detention, including those who have complied with the terms of their release for years, even decades, for redetention and removal to a third country. This directive to redetain places an untold number of non-citizen citizens at imminent risk of deprivation of life and deportation to a third country without the basic procedural protections of notice, opportunity to prevent or to present a fear-based claim. DHS's failure to provide a meaningful notice and opportunity to present a fear-based claim before deportation to a third country has caused and is causing irreparable harm. For example, OCG, a Guatemalan man, holy fuck, to whom IJ, I assume and the IJ immigration judge, granted protection from deportation to Guatemala. How can you expect Trump to follow the law? He isn't a lawyer. True. Thought he was being released from immigration detention when DHS instead placed him and approximately 20 other men on a bus without telling them where they were going, and they were being deported to Mexico. Okay. Jesus Christ. Had no notice, no opportunity to present his claim that he had been raped in Mexico, holy fuck, and feared prosecution and torture there. In Mexico, authorities gave plaintiff OCG the Hobson choice of waiting several months in detention to apply for asylum in Mexico, a country where he had been persecuted and feared further persecution, or being deported to Guatemala, a country where an IJ found it more likely than not he would be persecuted. He currently remains hiding in Guatemala. It's up in the air if people have rights. It needs to be tested in the Supreme Court. True. Plaintiffs on behalf of themselves and similarly situated individuals, so this means there's a class action, challenge DHS's policy of failing to provide meaningful notice and opportunity to present a fear-based claim prior to deportation to a third country, and DHS policy of redetention pursuant to February 18th, 2025 directive. Plaintiffs asked this court to declare these policies unlawful and to set them aside, to enjoin, which means stop, DHS from continuing to fail to provide meaningful advance notice in writing and the opportunity to present a fear-based claim to an IJ prior to any detention to a third country, and to order DHS to return plaintiff OCG and propose class members who have been deported without these procedural protections. Jurisdiction, venue, parties. Is there more? Okay, factual allegations. Okay, cool. Plaintiff DVD is a non-citizen from Cuba, resident of Massachusetts. He had a final removal order from 2017 following removal proceedings in which Cuba was the only country designated for removal. On March 28th, 2025, DVD faces imminent risk of redetention and deportation to a third country when he is required to report for an in-person check with U.S. Immigration and Customs Enforcement. Has the Supreme Court ever said that Congress people can't be deported? They've said that citizens can't be deported. I'm pretty sure. MM is a non-citizen from Honduras and a resident of Texas. In 2021, an IJ granted her application for withholding of removal to Honduras, the only country designated for removal, in withholding-only proceedings. April 4th, 2025, faces imminent risk of redetention. Okay. Okay, so this guy's actually detained. EFD, a non-citizen from Ecuador, resident in Massachusetts in 2018. Removal proceedings. So we'll probably copy this one because he's actually in detention at the moment. From Ecuador, reside in Texas. 2018, and removal proceedings in IJ granted his application for protection of deportation to Ecuador. March 18th, 2025, ICE and other agents took EFD and his co-workers into custody after a search for a different person was unsuccessful. He is currently detained in Massachusetts and risks imminent deportation to a third country. Also, I should probably link this somewhere. Fuck it, I'll do my usual citations. They're so time consuming. Like the formatting of embed links in Obsidian is kind of bad. Then this one was right at the beginning, I think. Yeah, page 3. Mexican authorities deported him to... following his deportation to Mexico, Mexican authorities deported him to Guatemala, the country from which the U.S. granted him protection, where he remains hiding to this day. Wow, okay. Crazy. In 1996, Congress enacted the Illegal Immigration Reform and Immigration Responsibility Act. The act generally retained prior procedures for removal hearings for all non-citizen, full immigration court hearings, appellate review before the Board of Immigration Appeals, and federal court review. In these removal proceedings, the non-citizen is entitled to select a country of removal. The immigration judge shall notify the respondent that if he or she is ordered removed, the country of removal will, in the first instance, be the only country designated for the respondent. The IJ will designate the country where the person is subject, national, or citizen. If either the non-citizen does not select the country, or as an alternative, in the event of a non-citizen's designated country does not accept the individual. The IJ also may designate alternative countries as set out in that law. For individuals who have been placed in Section 240 proceedings upon arrival, the statute provides designation to the country from which the individual boarded a vessel or aircraft, and that can consider them alternative countries. This goes into asylum. This is Convention Against Torture, which will provide them withholding withholding only proceedings, individuals who have been deported and subsequently returned to the United States without inspection are subject to summary removal process known as reinstatement of removal. This summary process is carried out by DHS officers. Individuals subject to reinstatement orders are barred from seeking most forms of relief from removal, including asylum. Some people who are not lawfully permanent residents are subject to a separate summary removal process. If a DH officer determines they are deportable due to an aggravated felony conviction, that process is also carried out by DHS officers, like individuals subject to reinstatement orders. However, the United States commitment to non-refoulement, the fundamental principle that no one shall be returned to a country where they would face prosecution, critical protections from removal remain available in reinstatement. Okay, is this just all... For individuals in removal proceedings, the designation of a country of removal on the record provides notice and an opportunity to permit the non-citizen who fears persecution or torture in a designated country to file an application for protection. That feels important. For individuals in removing proceedings, the designation of a country of removal on the record provides notice and an opportunity to permit a non-citizen who fears persecution or torture in a designated country to file for application for protection. Courts have repeatedly held that individuals cannot be removed to a country that was not properly designated by an IJ if they have feared of prosecution or torture in a country. Providing such notice and an opportunity to present a fear-based claim prior to deportation also implements the United States obligation under international law. Meaningful notice and opportunity to present a fear-based claim prior to deportation to a country where a person fears persecution or torture is also a fundamental to due process protections under the Fifth Amendment. I'm interested to see what cases they're listing here. The federal government has repeatedly acknowledged these obligations. In June 2001, the former Immigration and National Service drafted a document called Notice to Alien Removal to other than designated country. Which would have provided a non-citizen with written notice of deportation to a third country and a 15-day automatic stay of removal to allow the non-citizen to file an opposed motion to reopen removal proceedings and accompany Form I-589 protection application before an IJ. Almost 20 years later, in June 2020, DHS drafted a model notice of removal to other than a designated country. That likewise provided these protections. Okay. The Assistant Solicitor General represented that the government must provide a non-citizen with notice and opportunity to present a fear-based claim. Specifically at oral arguments in that case, the following exchange between Justice Kagan and Vivek Suri, Assistant to the Solicitor General, took place. Suppose that you have a third world country and that for whatever reason was willing to accept a non-citizen. If that non-citizen was currently in withholding proceedings, you couldn't put them on a plane to that third country, could you? Said we could after we provide the non-citizen notice that we were going to do that. Said, but without notice. So that's what it would depend on, right? That's that you would have to provide him notice. And if they had a fear-based persecution or torture in that country, he would be given the opportunity to contest his removal from that country. Isn't that right? So he said, yes, that's right. Interesting. Notice is only meaningful if it is presented sufficiently in advance of the deportation to stop the deportation, is in a language the person understands, and provides for an automatic stay of removal for the time period sufficient to permit the filing of a motion to reopen removal proceedings so the third country for removal may be designated as required under the regulations, and the non-citizen may present a fear-based claim. I want to hear a little bit more about this, yeah. A gay man from Guatemala. Oh, shit. That makes more... Oh. Gay Guatemalan man fled from the country after facing multiple death threats on his sexuality. This is page 24. He arrives at the U.S. border in March 2024 and attempts to present himself for inspection to seek asylum. At the border, he told DHS officers he was afraid to go back to Guatemala. After he spent about a week in immigration custody, DHS officers told OCG that he would be removed. OCG asked officers to have a credible fear interview, but DHS officers told him that it would not be possible without providing an explanation. He was summarily ordered removed pursuant to that criminal code and deported to Guatemala. Still unsafe, he fled Guatemala again and entered Mexico in April 2024. Shortly after arriving in Mexico, OCG was raped by one of the men who helped him reach the U.S.-Mexico border. These men locked OCG in a room for several days. OCG was let go after his sister paid the men, and he fled to the United States seeking protection. He was removed to the U.S., where he fled again. From the U.S., where he fled again to Mexico. OCG was raped by... How's it going, Antoine? One of the people helping him and held for ransom by one of the people helping him reach the U.S. border. I always throw an A in there for some reason. Told him he was ineligible for asylum. Asked the IJ if he could be deported to a country other than Guatemala and Mexico. Advised that Guatemala was already designated as a country of removal, but reassured him, we cannot send you back to Mexico, sir, because you are a native of Guatemala. Even though Mexico was not designated as a country or alternative country of removal in these proceedings. So he ended up getting... DHS assured him he would not be removed back to Mexico. DHS counsel stepped out of the courtroom for approximately 10 minutes and upon return indicated that the government waived appeal, remained at the detention center after he won withholding. So OCG won withholding from Guatemala. What % chance do you think there is for Supreme Court justices being deported? Right now, that would be a really, really big step. I haven't seen anything to indicate that that's where they're heading. But, I mean... Okay. Okay, so there's some of the info there. Seems like a decent case that they're not, you know, having their due process rights fulfilled. However, you know, not the strongest political case because these people are subject to removal. And then, is this the one? This is the one where it's ruled that they violated the thing. I'd say a solid 20%. I would say 80 if they fight him aggressively stealing elections or something. There'd have to be like a really, really big ruling against him in order for... Right now, I would say that percentage is like 2. Like, it's like 2%. There, I don't... That would be such a crazy, crazy step above what they've already done. Okay. So this is the introduction. This is called Plaintiff's Emergency Motion for Temporary Restraining Order and Preliminary Injunction on behalf of the class members and all similarly situated class members. Plaintiffs seek an emergency order enjoining defendants from effectuating the removal of class members NM and TTP and any other class members to South Sudan prior to making them board a plane for removal to that country. Defendants failed to comply with the court's preliminary injunction, specifically with respect to the class member NM. Trump is the will of the people. Why would you let these unelected judges control the nation? True. Give me 1 second. Let me see. Maybe I should read the preliminary injunction first. Appear under pseudonyms, memorandum in support, notion to certify the class, motion for a TRO. Memorandum in support, exhibits, motion for leave, electronic notice of case assignment, judge order, and considering jurisdiction. motion to appear. Notice of motion to hearing. Prepping preliminary injunction. Electronic order granting 25 assessed to motion, extending time to midnight. Plaintiffs from extending. Have you been following the Supreme Court arguments whether nationwide injunctions are illegal? I watched the one hearing and it didn't feel like they agreed. But I watched the one hearing regarding birthright. Appeal. Okay, did they... Motion order. Stay. For an indicative ruling on preliminary injunction. Order opposing. Reply to response. Motion hearing. Motion to stay by U.S. Department. Okay, here is the preliminary injunction, I believe. Okay. This is the, I believe, the preliminary injunction by the judge here. Okay. This case presents a simple question. Before the United States forcibly sends somebody to another country other than their country of origin, must that person be told where they're going and given a chance to tell the United States that they may be killed if sent there? Defendants argue that the United States may send a deportable alien to a country not of their origin, not where an immigration judge has ordered, where they may be imminently tortured and killed without providing that person any opportunity to tell deporting authorities that they face grave danger or death because of a deportation. All 9 sitting justices of the Supreme Court of the United States, the Assistant Solicitor General of the United States, Congress, common sense, basic decency, and this court all disagree. Plaintiffs seeking limited... Okay, so... That's a bar. When asked for a injunction preventing the deportation of the class, the judge says that insert link. Oh, add external link. Pop. Plaintiffs are seeking limited and measured remedy. One defendant has conceded in other proceedings that the minimum that comports with due process. Plaintiffs are simply asking that they be told where they're being deported to a new country before they are taken into custody and given the opportunity why such deportation will likely result in their death. This small modicum of process is mandated by the Constitution, and for that reason, the motion for class certification is granted, and the motion for a preliminary injunction is granted in part. I want to see the... I want to see, like, the summary. Okay. Thank you. Oh my god. I want to find it in the document, motherfucker. Can I just search the document? Show me in the text. Granted in part. Argue. This is the standard. The court has been forced to decide on an appropriate time limit because the defendants were unable, unwilling, or incapable of meaningfully engaging in a discussion about what process is required to provide aliens. To tailor its preliminary injunction as nearly as possible, the court has chosen to use the time frame that the defendants proposed when developing their own forms for the scenario. These forms may never be formally adopted. They would appear to, at the minimum, reflect the agency's determination on 2 separate occasions spanning the period of nearly 20 years of an appropriate period of time during which an alien is permitted to be deported. District Court remains substantial discretion to dictate the terms of an injunction. What's the TLDR so far? How's it going, Sanzel? So, the original case is that they were deporting people without giving them to countries other than their birth country and other than the countries that they have already discussed not needing to be deported to. So, in this case, OCG... he's a gay guy from Guatemala who was being persecuted in Guatemala, so he comes to the U.S., gets kicked out, then goes to Mexico, gets raped in Mexico, and then comes back to the U.S., and he gets a withholding from Guatemala, and then when he asks DHS, like, hey, am I going to be deported to Mexico? They say no, and then they deport him to Mexico without giving him the ability to challenge being deported to Mexico. So they sue because they're not being given enough notice to challenge the place that they're being deported to. So far, we're at the point where the judge has granted a preliminary injunction. What that injunction looks like so far, that's what I'm trying to figure out. But he granted a preliminary injunction, meaning that they can't deport these people until this is, litigated in the court. And then the next thing is probably... spoiler alert, violation of that injunction. But I guess it'll probably, expound upon what the injunction looked like in the thing. There was a big bar from the judge, though. It said, this case presents a simple question before the United States forcibly sends somebody into another country other than their country of origin. Must that person be told where they're going and be given the chance to tell the United States that they may be killed if they're sent there? Defendants argue that the United States may send deportable aliens to a country not of their origin, not where an immigration judge has ordered, where they may be imminently tortured and killed without providing any person any opportunity to tell the deporting authorities that they face grave danger of or death because of the deportation. All 9 sitting justices of the Supreme Court of the United States, 1 Solicitor General of the United States, Congress, common sense, and basic decency, and this court all disagree. That's fire. It's a fire statement. If I didn't have such a bad stutter. District Court remains substantial discretion to dictate the terms of injunction. So it looked like they just put the injunction on for a couple days. On March 23rd, 2025, plaintiffs filed a complaint, a motion for a temporary restraining order, and a preliminary injunction, and a stay of administrative action, and a motion for leave to appear under pseudonyms. On April 18th, 2025, the court granted the plaintiff's motion for class certification and preliminary injunction. The court required the defendants to... These are important steps. So 1, 2, 3, 4, 5. We'll do timeline of violation. April 18th, this court granted the plaintiff's class certification and preliminary injunction. court required the defendants to provide notice to the class member and the immigration counsel, if any, of the third country to defendants must provide a meaningful opportunity for the class member to raise a fear of return prior to any such removal, including the opportunity to demonstrate a reasonable fear of removal and a minimum of 15 days to move to reopen, even if an individual does not establish a reasonable fear. Provide meaningful opportunity for the... Okay. May 7th, after the media reports and reports from immigration attorneys indicated that the defendants were seeking to deport class members to Libya and Saudi Arabia, plaintiffs file an emergency TRO with evidence that had gathered at the time of filing. Plaintiffs received further information that NM was a class member among 13 other men defendants attempted to deport to Libya. The men were not provided notice and opportunity to seek CAT protection or Convention Against Torture protection. The men were ultimately transported back to an immigration detention center after remaining on a bus on the base's tarmac for 3 or 4 hours. Okay. Speaks very limited English. Best language is Karen. I didn't know that was a language. Received a final order of removal from Nebraska on August 2023. Then at 6:35 p.m., Mr. Ryan received a second email from the... Okay, wait, hold on. Received an email from the Supervisory Detention and Deportation Officer at Harlingen Field Office, providing a document to the officer alleged to have been served on NM. The document was a notice of removal to NM that ICE intended to remove him to South Africa. The certificate of service stated that the contents of the removal were to NM in English without an interpreter at 11:59, and that NM refused to sign the document. NM has limited English proficiency. Approximately 10 minutes later, he received a notification that the sender sought to recall the email before attaching notice of removal to South Africa. Mr. Ryan received a second email providing a document that the officer alleged to have been served to NM. The attachment, utilizing the same form as was for the notice to South Africa, stated that it was a notice of removal to inform NM that ICE intended to remove him to South Sudan. The certificate of service stated that the contents of the notice were read to NM in English without an interpreter at 17:48, and that NM refused to sign the document. After learning the news from NM's counsel on the morning, plaintiff's counsel asked defendants to request a halt to NM's deportation and or move him to the United States. Following this communication, plaintiff's counsel received a report regarding another individual, TTP, National Vietnam, that is also likely a class member who is or was on the same flight as NM. and this was on May 17th, 2025. Who's okay? Mr. Ryan is an IJ. I think that's probably good. Then when was this filed? 5/21, so May 21st. What the fuck is this judge's name? Give me 1 second. Oh, I forgot to transfer it back while I was reading. Just trust that all that's true. Oh, Brian E. Murphy is the judge's name. Okay, well, we can transfer back now. Oopsie poopsie. We all make mistakes. All right, we all make mistakes. Rules that the defendants violated the preliminary injunction entered into this case by failing to provide 6 non-citizen class members a meaningful opportunity to assert claims for protection under CAT before initiating removal to the third country. Forgot to copy, I think. Defendants maintain that the ambiguity of the phrase "meaningful opportunity" precipitated this controversy. Indeed, when the court issued the preliminary injunction, it declined to elaborate on what constitutes a meaningful opportunity, preferred instead to let experience show through hard cases the finer points of what is required under the Due Process Clause. To be clear, this is not one of the hard cases, giving every credit to the defendant's account that non-citizens had fewer than 24 hours notice, 0 business hours notice before being put on a plane and sent to a country, which the U.S. State Department issues the following warning: do not travel to South Sudan due to crime, kidnapping, and armed conflict. As detailed on the record of today's hearing, further facts regarding the unavailability of information, the hurried and confused notice that the individual received, language barriers, and the attorney's access compound and confirm this court's finding that no reasonable interpretation of the court's preliminary injunction could endorse yesterday's events. Man, conservatives talk about guns against a fascist government. Oh boy, wait, hold on. There was a lot I missed. Man, it feels like we almost need Judge Dredd style judges to enforce rules without the executive branch going rogue, like arrest cops and lawyers and the executive branch members. Like, these people who know what they're doing should go to jail for kidnapping and reckless endangerment. If a judge rules that it's reasonable to think harm will continue if someone if you deport them, then the government deports them. That is by definition reckless endangerment. Man, conservatives talk about using guns against a fascist government. All right, I'm not going to endorse anything you said there, but I mean, yeah, I mean, it's fucking crazy. Don't get me wrong. There's just some violent rhetoric there, which I'm not going to co-sign. Nevertheless, given the defendant's position that further detail would help the defendants comply, the court orders the following summary and clarification of its preliminary injunction. Following the notice, the individual must be given meaningful opportunity and a minimum of 10 days to raise a fear-based claim for protection removal. Okay. And then this is order on remedy. As set forth in today, violated the preliminary injunction. Having considered the arguments of the counsel, the court orders the remedies for the thing. Each of the 6 individuals must be given a reasonable fear interview in private with the opportunity for the individual to have counsel of their choosing present during the interview, either in person or remotely at the individual's choosing. Each individual must be afforded access to a counsel. This is just talking about the... making findings or conclusion that compliance with these processes before deportation would have satisfied the... Okay. During that 15-day period, the individual must remain within custody or control of DHS and must be afforded access to counsel that is commensurate with the access they would be afforded. Defendants must provide status reports 7 days to all individuals. Should any individual move to reopen, the party must also provide a status report. And that was filed today. Okay, well, yeah, I mean, pretty crazy. The argument that due process or a reasonable notice means less than a day is fucking insanity. And the idea that this is like an argument that people are trying to pretend is a good faith argument is ridiculous. It's insane. It's ridiculous. Now let me... Okay, that's fine. Let me link Sonsel this. Okay. Okay. Well, that's most of the reading I wanted to get out of the way. me personally. How are we feeling, buddies? How are we? I feel I don't know what to say. I don't know.